docket. That is case number 110393, State of Kansas v. Wyckoff.
May it please the Court, Brock Abbey, Assistant Saline County Attorney on behalf of the State of Kansas. And Mr. Chief Justice, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. And thank you again, Your Honors. It looks like we're here for DUI Day at the Kansas Supreme Court. This is an appeal, as the Court heard this morning, of KSA 8-10225, which is known as the test refusal law. It comes from Saline County District Court, wherein the District Court judge, based on a motion to suppress and dismiss filed by the defendant, Mr. Wyckoff, ruled that the case 8-1025 violates the Fourth Amendment to the United States Constitution, as well as the doctrine of unconstitutional conditions. Moving first, I'll discuss the Fourth Amendment, unless the Court has any questions first. I know you've heard argument about this morning, but the 8-1025 criminalizes a refusal to attest that's deemed consented to under the implied consent law, which is 8-1001. It does so only in cases where, applicable to this case, where a person, when they're over 18 years of age, has a prior conviction for DUI or DUI diversion, and not first-time offenders, I guess, is the important part. And that's important as it relates to, again, the purpose of the law we've been discussing is to reduce incidences of drunk driving and crashes and injuries and fatalities on the roadway. This is another way of doing that. It supports the purpose of the implied consent law to be a remedial law to protect the general public safety, health, and welfare. And the way it does that is a person who is arrested for DUI and there's probable cause to believe that and reasonable grounds to request testing, a law enforcement officer is required to ask them to submit to a test, and based on their answer, more importantly a no answer, is what triggers the applicability of this law, and it's that no answer that forms the basis of the charge in this case. The District Court, again, suppressed the evidence applicable to that offense. In other words, if we would have proceeded to trial, we wouldn't have been able to use that response as allowed under implied consent law as an inference of guilt in the prosecution of the DUI itself. But more importantly, it also dismissed that charge, finding it unconstitutional, which barred the state from prosecuting that offense. The state pursued an appeal based on the constitutionality of the statute, and in our brief cited obviously McNeely, the recent U.S. Supreme Court case, again, that addressed the exigent circumstances exception and made no real, at least not in its holding, maybe in dicta, addressed the implied consent laws by endorsing them and citing the significant consequences the states impose on persons who withdraw their consent, or put another way, I think we're splitting hairs when we say withdrawing consent or refusing a test deemed consented to. I think they're both the same thing. And going back at least to Burnett, the Ninth Circuit case we cited in Alaska in the 1980s has done this, has criminalized a refusal. And in that Burnett opinion, the Ninth Circuit noted that there's no right to refuse the breathalyzer, and that there's only a right to be, I guess in the alternative, you can't be arrested on less than probable cause. That's the right protected by the Fourth Amendment. And as noted in these instances, there would be the requisite of probable cause before anyone could ever be tested under this statute or requested to submit to a test. As noted in the 609 letter, since the state submitted its brief, there have been various other sister states that have considered this issue. In particular, within that 609 letter, we addressed State versus Juan. It's just a Hawaii Intermediate Court of Appeals opinion. I will tell you that in researching prior to coming here today that the Hawaii Supreme Court did grant, it's a petition for certiorari there. So that case is still pending appellate review. But it did uphold Hawaii's version of the statute, which imposes jail time and fines if a person refuses testing. And particularly noted that if a person were allowed to just withdraw their consent or refuse testing, that the purpose of the implied consent law would be defeated. It wouldn't have any purpose if you're deemed to have consented at this time, but at this later date you can vitiate that consent by just saying, no, I'm not going to take your test without consequences. There really wouldn't be any purpose to having the statute at all if that's all it took to withdraw that consent. And what we know is that this court has upheld the license suspensions for refusing that. So we have recognized that statute's allowed to be coercive.
And you don't see any distinction between the licensing procedure, suspended license, and denial of liberty interest by incarceration?
No, I think when you look at the state's interest in enacting the laws, the reasonableness of the law, what the Fourth Amendment requires, the state's interest is compelling, and it's, I guess, much less of an interest in just a pure administrative sanction.
Well, but we've said the driver's license is not a right; it's a privilege, and that's part of the reason behind what we allow on the administrative proceedings and to suspend your license. But we certainly have a constitutional right to our liberty, don't we?
Up until the point that obviously there's a conviction. If that's the analogy, you can't withdraw somebody's liberty, throw them in jail without a conviction, and that wouldn't happen.
But we're not searching after the conviction. We're searching before the conviction.
Right. So I think the question would then be, it's a privacy interest instead of a liberty interest.
Well, what I'm getting to is you seem to want to expand what we have allowed with regard to driver's license suspensions, which dealt with a privilege, not a right, to expand that to apply equally to the denial of a liberty interest, putting someone in jail.
Right.
Which is a constitutional or infringement, or a constitutional right.
If you're still asking about the Fourth Amendment, I think again the touchstone is reasonableness, and Skinner I think made clear that unreasonable searches are those that are unjustified or conducted in an improper manner. In this instance, I would submit that the state's compelling interest justifies it, makes it reasonable, and being conducted in an improper manner. A breath test is minimally intrusive. It searches deep lung air. You're asked to breathe or blow harder than a normal breath, but essentially just taking air from the lungs, which is minimally invasive. And I think McNeely recognized that as well, the minimally invasive nature of a breath test as opposed to a blood test.
Well, certainly the Fourth Amendment's touchstone is reasonableness, but we still have the presumption that a search is unconstitutional if it's not pursuant to a warrant. You have to find one of the exceptions to the warrant requirement.
There's a presumption that there is if it doesn't fit within a warrant requirement, but I think that's where you come back to the reasonableness. There still can be a balance conducted against with the government's interest against an individual's interest in conducting that search.
There's some kind of amorphous exception that hasn't been named before.
I call it reasonableness. It's reasonable, so it's not within the gambit of the Fourth Amendment.
But Skinner was one of those highly regulated industries.
Yes, railroad operators,
Railroad operators.
as is motorist drivers, required to be licensed. Vehicles are licensed.
Again, there's the commercial aspect, the necessity rule that's there. How does that apply to an individual right?
The commercial, I don't think applies to the individual right.
You don't think there's a distinction there between commercial regulation and regulation of individual rights?
I think the reason behind the commercial regulation in Skinner's present here, it was the probability or likely harm that would befall the public if we're allowing intoxicated or impaired railroad train operators to conduct trains. And that's certainly present here. The same danger, if not exponentially more, is present by allowing impaired operators to drive and saying at a later date we cannot test them for that when again there's probable cause, which I think goes into the reasonableness. It's not just somebody stopped for a speeding violation, we're going to take them to jail and see if they're under the influence, if there's any alcohol in their breath. It's people that law enforcement have gone through testing on and determined whether there's probable cause to arrest, and then obviously reasonable grounds to submit to testing. And as you heard in the first case this morning, there's an after effect or an after remedy for that in both the DUI realm as well as the test refusal realm, and that is a person can certainly file a motion to suppress and test the probable cause for the arrest or the reasonable grounds to submit to testing.
And if they win on that, do they still get prosecuted for the refusal?
I don't think so. I think
So how is that a remedy from criminalizing their exercising their right to insist on a lawful search? Why isn't that a substantive due process violation?
well, substantive due process.
Well,
I apologize, Judge. This wasn't a part of our case.
Well,
But.
okay. Well, that would be my next question. If you lose on, we say the Fourth Amendment doesn't apply, can we say but Fifth Amendment does, can we simply say the district court was correct for the wrong reason?
I would disagree that the Fifth Amendment applies. I think South Dakota versus Neville addressed that.
But my question was, if we decided on a different basis, would we have to remand and give you a second, or give the district court a second chance to look at this, or could we uphold based on another ground?
No, I think you could, Your Honor. I think that the Supreme Court precedent is that right for the wrong reasons is something the Supreme Court can do. I see I'm out of time.
What's the purpose of, keep getting back to this implied consent statute, and if the legislature has deemed the driver to have consented to having a needle stuck in their arm and blood drawn, then why even ask them for their permission? Why not just arrest them, drive them to the hospital, and stick a needle in them? It seems like there's a dance here that doesn't need to go on. Why criminalize refusal? Just, if it's been consented to, just go.
Well, I think that that's where the benefit comes in for the accused. If they agree to take the test, they avail themselves of either being under .08 or being within .08 and 0.15 and escaping the harsher sanction. I think that that's a reason to advise them of the implied consent advisory, because it contains that one.
Seems to be more coercive to me.
I don't believe it is, Your Honor. I think advising them of the legal remedies or legal consequences of their choice, whichever they make, it still leaves a choice open to them, is appropriate. I think it saves them confusion or the I didn't make a knowing decision argument.
Well, if the legislature can unilaterally declare that drivers are deemed to have consented because there are these dangerous results that they need to protect against, could the legislature say that selling cocaine is an inherently dangerous felony as designated by the legislature, so we're going to deem anyone that sells cocaine to have waived their Miranda rights?
No.
What's the difference?
The exceptions to the warrant requirement as opposed to The Miranda rule being a bright
So-
line rule, you have to,
How about waive their right, Fourth Amendment rights? That if you get caught, or there's probable cause to believe that you've sold cocaine, we can search your house, we can search whatever we want to, because you've consented to a search.
I don't think you could do that either, Judge, or Your Honor, I'm sorry. I think first, there's a distinction between the person and the house, and especially
Or,
in the
okay, we can search your person.
in the instance of the DUI,
And go in, we can search your car, search your person. We can do a full body search, see if you're hiding any drugs anywhere.
and they do that, Your Honor, under the search incident to arrest. When they come into jail, they do a full search for evidence
That's
of
different
crimes that can be
exception.
preserved.
That's a different exception. He's trying to get you to respond to this analog, this hypothetical analog.
Of if there's cocaine on their person.
Right. They just, no more Fourth Amendment.
I don't know if I can
Is that okay?
draw the comparison, I guess. The difference I would see is that in the DUI context, what we know is, and again, it goes back to McNeil, there's not a per se exigent circumstance, but alcohol dissipates. That's something that goes into the calculus, whereas the cocaine isn't going to just disappear.
Okay, we've dealt with the U.S. Supreme Court's dealt with the dissipation, but the real point here is we have constitutional rights, and we have court-made exceptions to those. Can the legislature declare its own exceptions to the Fourth Amendment warrant requirement? And that's basically, when they say you're deemed to consent, they've effectively said, here is an exception to the state of Kansas's requirement to get a warrant to search drivers, haven't they?
They have, to the extent that they're saying that the consent exception applies in this.
And how does that happen? How does the legislature have that authority to create an exception that doesn't exist otherwise?
Create an exception to the warrant requirement that doesn't exist otherwise?
Exception to constitutional rights.
Well, again, if it's the consent exception, it's already been recognized. It's just saying, in this instance, we're going to apply it by you driving on the roads. And I think the precedent and those other states that have upheld their test refusal rights have said it's reasonable to do that because of the state's compelling interest.
But the consent that we permit requires that it be a knowing, voluntary, and freely given consent. Correct?
Yes.
And you wouldn't say that this fits within that requirement, would you?
Yes, I disagree with what we're calling coercion here. Coercion would seemingly say that the state's getting the benefit for causing this. Again, I cited in the brief, the state's the victim. We get no benefit from somebody committing a crime. So if we're coercing them to submit to a test, and then in response to the question, they say no, we don't get any benefit from that.
You're contradicting yourself. Earlier in the other case, you said it's more difficult to prove that a person is intoxicated to the point of being incapable of safely operating the vehicle, and by coercing this test, you've eased the burden on the state to get the conviction.
We do. It does.
Okay, so you do get a benefit out of the coercion. Not you personally, but you as a representative of the people of the state of Kansas.
Right, but not in coercing the commission of the crime, coercing them to say no. We don't get a benefit there. If that's the distinction I see.
Okay, I see.
There's no further question.
I would like to explore this a little bit, and I come at what I think is the same issue from a slightly different direction. I understand that your argument is that from the previous case and this case that legal consent through the implied consent statutes given when a driver avails themselves of the benefit of driving on the state's roads, the privilege of driving. So there's sort of a bargain struck, and that's how the state elicits consent is through the granting of that privilege, right?
Yes.
And then your subsequent argument is that the state then coerces cooperation later, and that an individual cannot withdraw their consent, or at least that the state can attach sanctions to the withdrawal of the consent, right?
Yes.
So my question is this: given that context, that this is all happening in the context, arguably at least, from your position, of a bargain struck between the state and a driver, why shouldn't the sanctions that the state can impose be limited to that context? In other words, the context of the bargain is you imply consent, you consent, and we let you drive. So why shouldn't the sanction of withdrawing consent be limited to the state withdrawing the privilege of driving, rather than criminalizing the act and taking away somebody's liberty? In other words, I'm driving at the same question of trying to distinguish between the administrative side of this and the criminal side of it.
I think both the criminal sanction and the administrative sanction both have the same effect. That's how they're tied.
Well, they don't have the same effect on the defendant.
They have the same effect to the extent that they remove that person from the roadways. And I think that that's one of the purposes of the implied consent law, is to remove.
But you can remove someone from the state, can remove an individual from the roadways. In other words, you can revoke that contract, if you will. You can revoke the bargain by revoking their license. You don't have to go the extra step of putting them in jail or prison.
We can revoke their privilege to drive, but
Right.
that doesn't necessarily mean that they're not going to, as much as taking away their liberty to ensure that they can. And so before I close, again, the state's just asking that the court reverse the district court and reinstate that charge and remand to the district court for further proceedings. Thank you.
Any more questions? Thank you, counsel.
May it please the court, Roger Struble of Blackwell and Struble, Salina, Kansas, appearing on behalf of Darren Wyckoff, and in a sense defending the decision of Justice Jared Johnson finding 8-1025 unconstitutional. Having sat through the morning session, I'm going to probably use a Western Kansas phrase. I don't plan on trying to replow some already plowed ground. But I would like to make a comment on the implied consent statute itself. And there's been a lot of discussion about whether or not it's irrevocable, and that's the sense I'm picking up. The specific language in the statute later goes on to say, a person who is dead or unconscious shall be deemed not to have withdrawn the person's consent to such tests, which shall be administered in the manner provided by this section. So my argument on that point is simply that the legislature acknowledges in granting the implied consent that it's possible to withdraw that. And there are cases that basically say a person can withdraw their consent. The state argues that this is a tool creating a criminal sanction, and it's necessary in order to protect the roadways. What in effect has happened under the implied consent law is that if you refuse at the administrative level, your license is suspended, and it will be suspended for varying lengths of time. But you are then afforded an opportunity to get on the road again and drive a vehicle which contains an ignition interlock device. It certainly seems to be no better way to ensure safety from somebody who's already been convicted of a DUI to force them to drive, to continue their contract with the state, saying that I'm going to operate a motor vehicle under this privilege, and I'll do so with an interlock device. What the state has done here at the legislature by criminalizing this basically tells you that if you don't consent to giving a test, if you say no, you are going to be charged with a crime, and forces an individual to make a decision to give up their right to be free from an unreasonable search and seizure. As the court's pointed out repeatedly this morning, that a search without a warrant is deemed to be unreasonable unless it fits under certain circumstances. One being consent, which we've touched on, exigent circumstances, which McNeely has pretty much eliminated, and I heard argued this morning search incident to arrest. And it concerned me a little bit that there was a jump from I can search under Arizona versus Gant to protect my safety and to try to find evidence of the crime. And that was later developed in Riley versus California, where the court goes on to pretty much say that search for instrumentality of the crime or evidence of the crime is limited to personal effects. The court's not gone so far, the Supreme Court's not gone so far as to say that includes arbitrarily searching somebody's deep lung air, sticking them with a needle. That would not be search incident to arrest. So it's simply my contention that there needs to be a search warrant. Somebody's under arrest. They're taken down to the station, they're given the implied consent advisory. Under the current law, if they refuse, they're going to be charged with a crime. What's unclear to me is if I refuse, they go ahead and get a search warrant, and I'm then taken down and they're going to draw blood pursuant to the search warrant, and I say, okay, go ahead and draw my blood. Have I purged myself of the crime under the Standish case, which is a motor vehicle case? A person has a right while still in custody to change or revoke their previous refusal and consent. And so if I'm presented with a search warrant and I say, go ahead, here's my arm, take my blood, could I still be prosecuted? And under the elements of the crime, I guess the answer would be yes, because I've previously refused. And what the legislature is doing is forcing me to choose between my civil remedies, which is take my license, versus take my liberty and put me in jail. It's a statute that the compelling state interest says we want to try to eliminate impaired drivers. I would set forth the argument that there are other ways to do that, and it's already been accomplished. It just seems to be a further erosion of rights, and the Fourth Amendment cannot be whittled away by the legislature. I do acknowledge in Justice Johnson's argument, if I understood correctly, could they pass a law that would take away my Fourth Amendment right dealing with drug crimes? Quite frankly, the answer would probably be yes. The legislature could pass that law, but we'd be right back here again, relying upon the Constitution that says that's unconstitutional. The legislature, and that's what they've done in this case, as far as forcing somebody to either take a test or get charged with a crime.
But there was no search here.
There was not in this case.
And so if we were to say that, well, that wasn't really a Fourth Amendment violation because there wasn't an unlawful search, but it was a Fifth Amendment due process violation because you were denied your right to insist on a lawful search. You understand what I'm saying?
I do understand.
Then we would have the court in this case, and we would say that was that violation under these facts. We would be saying that the district court reached the correct result, but for the wrong reason. Would we need to remand that? Or would there be issues as to whether there was any exigencies in this case, or you understand what I'm saying?
I do, and the short response would be I would love for you to find that he made the right decision for the wrong reasons and leave it at that and find the statute
sure.
unconstitutional. But in all candor, it could go back for finding the facts. What's a little unclear to me is what McNeely did, in fact, leave open as far as what are these supposed exigent circumstances that might obviate the need for a search warrant. And I'm having some difficulty trying to come up with that circumstance where it would be impossible in this day and age to readily obtain a search warrant. The time frame of 3 hours, and we're taking this in the DUI spectrum, and that's, I'm assuming, the exigent circumstance to get that warrant would be for. They have up to 3 hours to obtain that warrant. Certainly, well, like I said, I really cannot come up with a circumstance that I think would meet that test, I believe, and would submit that this court should find the statute's unconstitutional on its face because it creates a crime.
The one I've wondered about, and maybe you can help me, you may know more about the science of this than I do, is if you have an accident where there are injuries to the drunk driver.
Okay.
So that there would be immediate medical care, including IVs with large infusion of fluids into the body. I don't know how quickly that would cause the blood alcohol level to dissipate. It would be so fast that they would need to do a blood draw almost contemporaneously with having started the infusion of the fluids.
My experience in dealing with autopsies, probably more than in this situation, although I've recently had a case where somebody was involved in an accident. The trooper sent his cohort to the hospital to say as soon as possible, you can't just draw blood. I've had that situation before. And rely upon the fact that my older sister is a chemist that runs the lab. I don't believe that it would affect the infusion of those fluids necessary to preserve life, unless it would be blood, would affect what a person's blood alcohol content is. One of the things that would be done...
A quick blood transfusion at mine.
Right. That's the only thing I could come up with. But I would also say it's generally hospital policy when somebody shows up in the emergency room, they immediately do a test for alcohol. The reason is not for prosecution of a DUI, but it's for in the proper administration of whatever drugs are needed to be given. If obviously somebody comes in and they've got something in their blood that might affect the drugs that they're going to give, they want to know that. So at least our hospital in Salina always runs that quick test. And that is not the evidentiary test. Oftentimes when that line is opened up by the nurse or who's ever in the emergency room, the law enforcement officer brings with him his kit from the KBI and hands it to him and says, okay, when it's convenient, go ahead and I need these tubes filled.
You are not in this case taking the position that the state didn't have the right to obtain a warrant under the implied consent statute? And that related to that, are you familiar with the split of decisions of our Court of Appeals with at least one panel saying that the implied consent deprives them of that ability?
Well, and yeah, I think all counsel this morning are asking for some clarity from this court as to what can be allowed. I would contend that the obtaining of a search warrant falls under normal judicial process, and Salina has taken efforts to short circuit that. They carry their iPads. It pretty much has a boilerplate with just a couple of places they fill in. They electronically communicate that with the district court judge who's on call that night, and a warrant gets issued. And it generally will authorize the arresting officer to produce blood, breath, or urine. One of the things that concerned me about this after the fact correcting is the line of cases that basically give an officer good faith. Well, I'm violating the law, but I was doing so, even though it's a bad law, I was doing it in good faith. And part of the after effect of a warrant or a motion to suppress deals with the fact that the reason we suppress evidence is to deter police conduct. And I cannot understand in this circumstance, on an individual basis where you address that, you're going to deter any kind of police conduct. They're going to continue to do that in every case, regardless. And it will not have a detrimental effect to law enforcement. Are there any other questions or points? If not, I'm asking the court to find the statute to be unconstitutional on its face, to find that it does violate my client's right under the Fourth Amendment to require a search warrant before evidence is taken from him, and that it is necessarily a position to take with this court that the legislature has overstepped for what Judge Johnson refers to as an admirable goal, but it's just gone too far. And if this court allows this procedure to go further, and I would state, having actually had the experience of trying a case where there was a refusal charge along with the DUI, based on my experience, had those two charges been tried separately, there would have been no conviction. There was no evidence that my client could have not operated the vehicle safely if it were tried simply on that. But when the jury was instructed, in addition, that if you refuse this, he's guilty of a crime, there was a carryover effect and he was convicted of both charges. So there is, in a sense of trying to get a fair trial on behalf of the defendant, the statute essentially eliminates that, forcing an individual to give up his liberty. With that, no further questions. Thank you very much.
Any more questions? Thank you, counsel.
If I can begin, I'll go back to Justice Luker's question about the split among the Court of Appeals, and if I understood the question would be the Hefner opinion and the City of Dodge City versus Webb.
Yes.
And the split between those was one panel said that you can't get a search warrant in a DUI case, and the other one said you could. And I think more specifically in the Webb case, the Kansas Court of Appeals said that if there's probable cause and the state could have got a warrant, then that's all we needed. You didn't actually have to get the warrant as long as you could have, supported by probable cause. Is there any further question along that line? Did I answer your question first, or?
Do you believe that you would have an officer would have the authority to get a warrant after a driver refused consent?
Yes, I think the statute explicitly within it says that regardless of what's implied as far as consent, it doesn't affect the state's ability to get a warrant or otherwise lawful means of getting a test. With regard to prosecuting the instances with the exigent circumstances, just a few come to mind, and they're generally in the hospital context too, where, as the previous questions were, somebody who's in a rollover accident and injured, and they're going in for either immediate treatment or immediate surgery, and law enforcement isn't going to have access to them in the time allotted, or they're going to be, and this may even happen in the ambulance before they get to the hospital, but they're going to be administered pain meds. And that's going to affect any prosecution for DUI, whether we get a blood draw subsequent to that. Obviously, any chemical testing on the blood would show that substance as well as anything that they may have been under the influence at the time of operating. So I think that could create an exigent circumstances left open by McNeely. I also think there's also within the Kansas statute that there's the 3-hour requirement. Exigency could be created by, and it occasionally does happen in Sling County where we can't get a hold of a judge. And so if you're running up against that time, I think that there may be an exigency created by the statute itself, that there's a time buttress that the state has to get the sample, or again, just the natural dissipation of alcohol, and there's not the option or availability to get a warrant. I think I have responded as much as I wanted to, unless there are any further questions from the court.
Any more questions? Thank you, counsel.
Thank you
both for your arguments this morning. Court will take this matter under advisement. We turn to